Hello, in this video, we'll discuss the difference between breach of contract and fraud in the context of civil law. Essentially, when two parties enter into a valid agreement, they are legally bound to fulfill the terms of that agreement. If one party fails to meet those obligations, this act is called breach of contract, which falls under civil law. It's important to note that not every failure to fulfill an agreement can be considered fraud. According to the Burgerlijk Wetboek B.W., specifically Article 1365, if someone fails to keep a promise in a legally binding agreement, it is classified as. However, in practice, people who fail to fulfill agreements are often reported to the authorities on charges of fraud. So, how do we differentiate breach of contract from fraud? The Supreme Court has consistently ruled that if an agreement is made in good faith and there is no dishonest intent, then failure to fulfill the agreement does not constitute fraud but is purely a civil matter. This means that the party in breach cannot be criminally prosecuted. However, if there is evidence of bad faith in the agreement, for example, if the party had the intention to deceive from the start, then the case could be considered fraud and fall under criminal law. In conclusion, to determine whether a breach of contract amounts to fraud or is simply a civil issue, we must examine whether the agreement was made in bad faith or not. I hope this information helps clarify the difference between breach of contract and fraud. Remember to always be cautious when entering into agreements, and make sure everything is done in good faith.